Hi, good afternoon, everyone. And I'm Judge Emanuela Groves with the Ohio 8th District Court of Appeals. And the next hour we will spend on talking about the appellate judge. And notice it's not judges, the appellate judge standing as the 13th juror in addressing issues of implicit bias in criminal cases. Professor Andrew Paulus will be the presenter this afternoon. He runs the Appellate Clinic here at Case Western Reserve University. And he started off back in 2008 as a visiting professor, and now he runs the clinic. And I'm sure for those of you that are now practicing, you know the impact, if you had an opportunity to be a student in the clinic, the practical experience that you get. And here at Case for the last couple of years, the students have experienced quite a bit of success. And I don't know, I know as a trial judge and even as a practitioner, when you go against these students, they're pretty prepared and they're very zealous. And it's just a joy to see them, and particularly when they are successful. So we will hear about this issue. And then one of the things too that I asked Professor Paulus is what one of his hobbies, and he said it's gardening and growing tomatoes. And I think that probably ties into the profession when you see young students and you see as they blossom and you see the opportunity to present in court. And so at this time, I present to you, Professor Paulus.
Thank you so much, Judge Groves. What a lovely introduction. Judge Groves was among a panel of 3 Case alumni. Judge Forbes was also on that panel, who visited here at the law school just last week. And some of the things that came up in that discussion, even though it was a reasonable stop case, it still had some very interesting implications that dovetail somewhat with my research that I'm going to be talking with you about today. So the thrust of my conclusion, basically the suggestion that I'm about to try to convince you to buy into, is theoretical. This is not the law. You have heard a lot of practical information at this seminar. And then just now through Judge Gallagher, we heard a really wonderful historical information. One of the things I was just telling Judge Gallagher about his presentation that I enjoyed so much was that it reinserted the humanity of those cases into the picture. So you're not just dealing with abstract rules or even concrete legal doctrines, but you're dealing with the people whose lives were really affected by those cases. And that's part of what drove me to this research. I have a very keen interest in the 1930s case of the Scottsboro boys. For those of you who aren't familiar, they were 9 African-American teenagers. They really were boys. It isn't just a disparaging concept. They were children who were riding a boxcar in Alabama. And when they were removed from the train, there were also 2 white females on that train who were worried that they could be arrested for vagrancy or what have you. So immediately the 2 white females pointed to the 9 African-American boys and said, "We were raped by these boys." There was no physical evidence, but a jury convicted them in just about 10 minutes of deliberation time in each of the separate trials. And eventually, there were 2 Supreme Court cases actually that were driven by this. One of them was Powell versus Alabama, which was one of the early cases establishing the right to counsel even in state court proceedings. There had not yet been a full due process incorporation of that right, but in that case, they held it as sort of a precursor to Gideon. And the other case was Norris versus Alabama, which was a subsequent appeal from the Alabama court system's systematic exclusion of African-American jurors from the jury rolls so that everyone was guaranteed an all-white jury. And the Supreme Court said, no, that's not okay either. So the case has really been interesting to me for a number of years. And Judge Groves just mentioned that she brought up Brian Stevenson, who works for the Equal Justice Initiative. I guess, Judge Groves, your daughter has an internship there. Well, Brian Stevenson, I'm getting confused with our dean. Brian Stevenson and Judge Blackman, who is formerly of the 8th District, were participating with me on a panel to discuss the Scottsboro case several years ago. And it really raises some interesting questions about the role that racial injustice plays in our criminal justice system, not back just in the 1930s, but going all the way down to today. And so that kind of sparked in me the idea when I started helping my appellate students learn about the various things that you can argue on appeal, it dawned on me that this entire concept of manifest weight, which we in Ohio come to sort of understand as sort of a ubiquitous appellate remedy that is almost never actually afforded anyone. But I was very surprised to learn that most jurisdictions, Ohio is a very strong exception, don't have any manifest weight review on appeal. They have trial judges who are permitted to entertain motions for new trial based on manifest weight. But then that decision of the trial judge is reviewed on appeal by an appellate court for abuse of discretion. There is really nothing in the country, with a couple of states with handful of exceptions of a couple of states, nothing as robust as Ohio. But I would argue that Ohio isn't robust enough. And that's the sort of genesis of this research. So this is a paper that I wrote that's coming out in a couple of months in the Temple Law Review. It's the same as the title of my presentation. And I've already shared with you a little bit about where this research comes from, but what I haven't mentioned yet, and it's really kind of the foundation of much of this research, is the concept of implicit bias. Many of us have come to be familiar with the phrase implicit bias. There is actually an online test that you can take that Harvard posts on its website. It's called the Implicit Bias Association Test. You can Google it and take it. There's a link to it in the article, which is among your written materials. But basically, the concept is that no matter who you are, no matter what color you are, no matter what gender you are, no matter what age you are, you harbor implicit biases. And it doesn't even matter how well-intentioned you are in your effort to shed them, because they're always there. And only a deliberate, conscious effort to overcome them can possibly rise to the level that it needs to for them not to infect the decisions that we make. Now, I don't mean to suggest that implicit bias is always bad. It's always bad when it comes to things like race and gender and sex and age and so forth. But it's part of the ways our brain is trained to work. We can't function in society without jumping to conclusions sometimes, because some of the decisions that we have to make need to be made very quickly, but not court decisions, not decisions that affect people's lives. And so to give you a little bit of an understanding of what I mean, what do you see here? Raw egg. System one processing, that's the intuition. That's the part of our brain that sees something and draws a conclusion immediately. And so system one processing tells you, as most of you suggested, that this is a raw egg in a bowl. But it isn't. System two processing, that is when we actually investigate and we look at it closely and we inform ourselves about it, what it really is, rather than just assuming it is what we think it is when we first see it. System two processing, that I am now allowing you to use because I'm giving you the information, will tell you that this is not an egg. It is half of a peach in a canned syrup, a canned peach in a bowl. But we all look at it and we think egg. Now imagine if somebody's life or liberty were at stake, and the decision that was made about whether to put that person away or even execute that person were based on something as erroneous as our collective conclusion that when you first see this thing, that it's an egg. And that's kind of where this differentiation between system one processing and system two processing comes in. And of course, the system one process, oh, well, here's another example. System one processing would tell us this is a picture of an animal. It's actually just a misshapen muffin. That says that you didn't jump to the same conclusion that most people would, that it was a peach rather than an egg rather than a peach. And that's kind of an important point. I'm glad that you raised it, because not all of our system one processing leads us all to the same place, right? In that particular example, most of us thought it was an egg, but obviously you just thought it was food. that is a function of the way your system one processing worked in that particular situation, which is in turn a function of your life experience, the way your brain has been trained, the way you were brought up, the experiences that you have had. All of those things contribute to the way your brain systematically, automatically, intuitively reaches conclusions. Similarly here, this is not a mouse. I wouldn't want to eat this muffin, but it happens to be just a muffin. But your first impression of it might not have said to you, that's a muffin. So let's look at what system processing is. System one processing. System one processing is intuitive. That is, we intuitively think we know the answer to a question. It's based on preconceived, internalized, and sometimes even unknown beliefs that we have, or ways that our brain has been trained to think. By contrast, system two processing is deliberative, thoughtful, and receptive to new information. So when you think about the way that system one and system two processing intersect with each other, system one processing might be the thing that you think when you first encounter a situation that requires you or even inspires your brain to form a conclusion, whereas system two processing is the thing that you can use to overcome or confirm your original perspective, right? Which of these two gives rise to problems caused by implicit bias? I've already sort of given away the answer. It's the first one, right? System one processing is the part of our brain's operation. And this is not my research. I borrowed this from other people because I'm not a psychologist or a neurologist or any of those things. But this is, in fact, the kind of the methodology and the terminology that social scientists use and psychologists use to help us understand the way that we think so that we can adjust our thinking when circumstances are appropriate. So that's the background on the processing pieces of it. What are the trial dangers of system one processing? Well, they are what you might intuitively imagine that they are. You can be, the outcome can be negatively affected by jurors' own baseline, sometimes race-based implicit biases. And research has documented a number of different discrete ways that a juror approaching a decision in a criminal trial, for example, will form conclusions that are based upon that juror's own system one thinking. It can be the criminal propensity of a particular defendant, not based on evidence, but based on whatever the juror might perceive about that defendant. It can be the credibility of a defendant. You might have a preconceived notion that people who appear a certain way are more credible than people who appear another way. Behavioral reactions is a big one. A lot of us think that other people in the world are going to respond to the same stimuli the way that we do, such as being stopped by the police. Some people behave very differently from other people when we are stopped by police. And that can be a function of our own life experiences, how we were raised, what we were taught to believe. Skin color goes into that, obviously, very importantly. But the question is, when you're sitting on a jury and your reaction to a police stop isn't the same as the defendant's reaction to the police stop, your system one processing, can you overcome that and recognize that not everybody is going to react to that same situation the way you would? Meaning, just because somebody chose to flee does not necessarily justify an inference of guilt. It can, but it doesn't necessarily. And then finally, the accuracy of confessions. We know that some people, when they interact with police, are more likely to confess to crimes that they did not commit because of the circumstances of the interrogation. And race is one of the many things that can play a role in that. So when a juror hears that a defendant has confessed to the crime, but doesn't have the background or the necessary system one processing to conclude that that confession might have not been a true confession, or it might have been a coerced confession, that particular juror may have system one processing that makes that juror less receptive to the argument that it was a coerced confession. And without intervention, that juror might in fact bring those preconceived notions to that juror's decision. And then finally, the last of these is that Witnesses are notoriously bad at identifying accurately the defendant who actually did the deed if the witness and the defendant are not of the same race. Cross-racial identification is really problematic, and the social science bears that out as well. So this is how a person who is not guilty of a crime through the manifestations of these various system one processings could be found guilty by a jury. And that leads us to the wrongful conviction rate, which is unknowable, obviously, but it is thought to be somewhere between 2 and 10% of our incarcerated individuals are improperly incarcerated. Yep.
I don't know if that figure is a totality, in other words, plea and trials, or is that just a trial?
It depends on which, that's why there's a range, but it depends on what study that you're looking for. But this is essentially about trial results, except to the extent that people are convinced to plead guilty because of the aspects of the case that their lawyers advise them are going to go against them. So some of these statistics, depending on which study you look at, do include resolutions short of trial. What's the actual absolute number that translates to? There are 46 to 230,000 people who have been convicted, and based on the percentages, these people are all convicted for crimes that they did not commit. Now, one of the things that obviously has got a lot of attention lately in legal circles is the DNA exoneration. The Innocent Project has done a lot of that. But bear in mind that not every crime is a crime for which DNA supplies that kind of information, right? Certainly there are crimes in which bodily fluids are left behind, and that's testable. But there are a lot of crimes, particularly lower level crimes, but still felonies, many of them, where there is no way of using DNA to exonerate someone who was convicted wrongly. So there's just no built-in method in our system to really attack this number, which is obviously an untenably high number. So let's talk about why the existing world of appellate review is inadequate to the task of dealing with these kinds of wrongful convictions. So first of all, procedural error is coincidental. What do I mean by that? Well, what I mean by that is that in our clinic, and some of my students are here with us today, in our clinic, we go through kind of a laundry list of different possible errors to look for when a defendant is convicted and wants to appeal. Some of these lists of things, sort of checklists, they come from different courts that have Anders briefing criteria that they require appellate counsel to look at to make sure that you don't miss something in the record that might support reversal. And most of those things, most of those ways of conventionally reversing a criminal conviction are procedural. Speedy trial rights, Fourth Amendment issues, something that went wrong in the evidence at trial. These are procedural things built into our system that are wonderful to have, but we cannot assume that every wrongfully convicted person suffered one of those missteps during the trial process, because these are, in essence, disconnected from the actual guilt or innocence of the person who has been convicted. So procedural error is great when you've got it, but it doesn't really speak to this problem. So what about sufficiency review? Well, what is the standard that an appellate court actually uses when giving a sufficiency review? Jackson versus Virginia is the key US Supreme Court's case that says sufficiency review requires proof from which a reasonable jury could find no reasonable doubt as to every element of the crime. That's terrific, right? It's great language. We're going to hold every jury to the reasonable doubt standard on every element of the crime. Great. But it's not that a reasonable jury should or should not. It's could find. It's could find. It's theoretical. So regardless of what the actual jury decision was based on, regardless of whether a weak case that nevertheless survives the sufficiency challenge was decided against the defendant, not because the evidence was overwhelming, but because the jury, for whatever reason, chose to believe the evidence that was adverse to the defendant. And to the extent that that decision on the jury's part was infected by one of the implicit bias factors that I talked about a few minutes ago, by system one processing, to the extent that, and not the compelling nature or quantity of the evidence, was the reason why there was a conviction, a sufficiency review will never get you a reversal. So all the prosecution ever needs to do is check the box for each element. And as long as there is evidence sufficient for a jury to find no reasonable doubt, regardless of whether their own deliberation process is actually looking at it that way, this is not a defendant-friendly standard. And it certainly doesn't empower the appellate court to overturn the substance of most criminal convictions. Then you look at the United States Supreme Court as sort of representative of the judiciary across the United States. And although it's a little more diverse now than it was last year, it is still not representative of the overall population of criminal defendants, certainly not representative of the overall population of convicted criminal defendants. And I forgot to mention when I showed you that 200,000 number, it is disproportionately made up of people of color. Very, very disproportionately. So yes, we're doing a little better in the composition of our judiciary, but if you need a majority vote to get the kind of relief that a criminal defendant is looking for, then presuming that you are going to get different implicit biases based on different features of the judge, race, ethnicity, skin color, age, experience, judicial philosophy, and on and on and on, the composition of the courts that review criminal convictions is obviously going to be affected by the personalities and experiences of the people who come to the bench, bringing with them whatever intuitive thinking they have. Then we get to this concept of affirmation bias. So for our appellate judges in the room, forgive me if this is somewhat, it is a critique of appellate review generally, not of any particular judge in this room. But what is affirmation bias? What do you think it is?
The overwhelming number of decisions are affirmed.
The overwhelming number of decisions are affirmed. Why though? What is it that makes it a bias?
Yeah.
Primacy, the decision was already made then.
Right. All of us tend to have a preconceived notion that if somebody decided something before we are faced with the question, then that decision is likely to be better than the one that we are being asked to make in the other direction. It's not just judges, of course. It's anytime you know that somebody holds an opinion, it's going to carry sway with you, obviously, depending upon who it is that holds the opinion. But there is a documented affirmation bias in the US judicial system that has been tested empirically, and that when judges are told about a result and then asked to see if they agree with it, they will agree with it much more readily than if they are presented with the same facts, but without that additional piece of information that somebody already held a particular way. That's what affirmation bias is. Okay. Whoops, what did I do, Rob? Thank you, Rob. Rob is my hero. All right. So it really does give the appellate court that extra imprimatur of integrity or reliability that is actually not supposed to be part of what the appellate review process is about. So you have our poor, unfortunate criminal defendant here who is theoretically at risk for being wrongfully convicted based upon implicit bias as that can play out in the jury system. And then you've got the Jackson standard layered on top of that, which is not an adequate basis, as I mentioned, for really getting to the substance of whether the conviction was right or wrong on the facts. And then affirmation bias on top of that. And where does that leave our criminal defendant? Without much of an appellate remedy for any of the substantive problems with the conviction. Still there for procedural problems, but not for substance, okay? So what do we do about that? Well, there is, as I mentioned, in most jurisdictions, an opportunity to challenge factual review or to challenge the factual accuracy of a conviction in the trial court itself. In most jurisdictions, there is the right to ask the trial court to grant a new trial after the fact. In civil cases, we have Rule 59. In criminal cases, I can't remember the rule number, but the rule that gives rise to that relief isn't just about the weight of the evidence. It's about anything that you can argue went wrong in the trial. The point is that the rule is there to give the trial court judge that power to intercept or override a conviction that might have been tainted by one of the manifestations of implicit bias. So the trial court has that power, but the trial court does not frequently use that power. And when the trial court denies a motion for a new trial, it goes up to the Court of Appeals and gets reviewed for abuse of discretion, which, as one scholar has said, by that time, there's really not a lot of meat in the broth anymore. So that, the abuse of discretion standard is obviously a very, very weak standard of review that does not give an appellant a real good shot at getting a trial court decision overruled. And this is not Ohio specific. This is actually not Ohio. This is throughout most of the country, that this is the only way in most jurisdictions that somebody who is truly aggrieved by an incorrect factual determination that led to a conviction, this is the remedy. That's it. And what that ends up doing, all the power is here. Of course, the power is in the jury as well, but all the legal power is here. The abuse of discretion standard is not going to step in very often to override the decision of that judge to deny the motion for new trial based upon whatever went wrong in the trial court proceedings. It just doesn't happen very much. So this power is basically the power that I am seeking to challenge here. I think it's too much power vested in one single individual. Why are appellate courts reluctant to disturb a jury's factual findings? Why? What do you think? What are the reasons why? Yep.
Courtroom, the accused and witnesses, better determinations, seeing the person firsthand.
So the answer given for those who are not able to hear it live is essentially one of institutional competency. The concept is that jurors have the better vantage point to assess things like credibility and to sort out inconsistencies in the evidence. That jurors are there, they witness the demeanor, they bring their life experiences, which is not always bad, right? We want juries comprised of our peers, if they're truly our peers. But the idea is that appellate courts are not in the business of doing that fact finding because they're not there in the courtroom when the evidence is presented and they don't have that vantage point. There's another explanation for it as well, which is tradition. We people are really not good at bucking against tradition for the very fact that it's tradition, right? The first song in Fiddler on the Roof is tradition. We do things because of tradition. They are built into our system. Our common law tradition is a tradition. The prior cases that we rely on them because it's tradition. We don't want to change things. And so there is a traditional argument that the traditional province of the jury is to judge the facts, and the traditional province of the appellate court is to apply the law. And the second reason is what you said, notions of relative institutional competency, for the very reason that jurors are there in the courtroom and are perceived to be better adjudicators of witness credibility and the like than appellate judges who are looking at the cold record. Both of these don't really hold up. The tradition argument is based on the historic right to a jury trial. In criminal cases, that right is conferred on criminal defendants by virtue of the Sixth Amendment. Does that look like tradition from a standpoint of a criminal defendant seeking to appeal a conviction? The accused shall enjoy the right to a jury. The state is not listed there as having the right to the jury. The appellate court certainly isn't listed there as having the right to a jury. That traditional right, to the extent we value it for more than just the sake of doing the same thing we've always done, belongs to the individual on trial. And because it is the individual's right to have a jury trial, it is also the individual's right, if you follow the logic, to tell the appellate court, I would like you now to do what the jury did not do. So the traditional argument against appellate review of facts isn't really borne out by the particular circumstance in which a criminal defendant seeks to overturn the factual basis of a conviction on appeal. What about the notions of relative institutional competency? What about that? This is the one you articulated, and it's the one that really has the most compelling legal support for it if you do, you dig through the case law. So the idea is that the judge who is sitting at the trial and facilitating the witness's testimony is not evaluating credibility. That is left for the jury to do, and the jury is there seeing it. And then the judge, who might be asked afterwards to grant a new trial, also saw it. So everybody in the room saw what the witnesses all said, what the evidence was. They are in a better position, so goes the argument, to decide if there was something wrong with that evidence or wrong with the process that led to the conviction. But guess what? It's not that simple. The transcript, that cold record, the white pages with black lettering on them, the thing that is often invoked as the justification for deferring to the jury with its greater competency, is actually a pretty darn good way of checking to see if the jury got those credibility determinations or the sorting out of the evidence correct. What can you do with a transcript that you cannot do in the jury box? You can sift back and forth the pages and see if testimony was maybe different from how the jury heard it when you actually look at the words. You can compare whether testimony from one witness actually contradicted another. You can compare whether the testimony of the same witness contradicted itself. And while a jury is there to hear those things, they don't always catch those things because they go by in an instant. Whereas the study that an appellate court can give to that cold record is a much better backstop against a jury's improper resolution of factual questions against a defendant. Now, I am not here to argue to you that it should all be done by the appellate court. We can live with both, right? We can give that jury the first pass at making those determinations. Without in any way watering that down, though, we can also give the appellate court a greater role in determining whether or not that jury acted reasonably in convicting a defendant. Okay, so that dispenses with the traditional notions that an appellate court shouldn't do this, and it essentially undercuts the setup that we now have in 48 of our states, with Ohio being one of the exceptions, or maybe 47. So if the appellate court orders a new trial when the conviction appears to be contrary to the manifest weight of the evidence, which is what Ohio judges already have the power to do, we'll talk a little bit more about that, then we can guarantee that the appellate court is truly sitting as the 13th juror, as the case law suggests that it should, and it's supposed to reassess credibility and reweigh the evidence. Now, one of my former students is here and knows that we have seen some conflict in 8th District decisions on this very point. I think Judge Sean Gallagher is a big proponent of doing a full credibility review on manifest weight. And I think there are other articulations of the manifest weight standard in the 8th District that say we defer to the jury's fact finding. So that's, by the way, an en banc conflict that maybe one day will get resolved, right? In fact, the Supreme Court just dismissed a case called State versus Metz in which that issue actually came up. And so I was hoping we would get some resolution to it. In any event, the key here, 13th juror, that language 13th juror that you see in every Ohio manifest weight decision comes actually from a US Supreme Court case called Tibbs versus Florida. And in Tibbs versus Florida, the Florida Supreme Court had overturned a defendant's conviction, and the debate was this a sufficiency reversal or a fact reversal? They don't call it manifest weight everywhere. And what the Supreme Court basically said is, if it's a sufficiency reversal, then double jeopardy prevents a retrial. But if it's only a factual weight reversal, then the remedy is a new trial, and double jeopardy does not step into the picture because it is a factual review that initiated by the defendant that does not deprive the state of the opportunity to retry. So that distinction was drawn, but here's the key. Think about that phrase, 13th juror. What does it mean? What work does that phrase do in the case law? Yep. SCOTUS said it, but it was reviewing the Florida Supreme Court's decision. And what does 13th juror mean? What it means is we've got 12 jurors sitting in the courtroom. What happens if one of them refuses to budge and the other 11 all say guilty? And they do the charge and the jury says, sorry, we can't resolve it. We have one holdout. What happens?
Trial.
It's a mistrial. And then a retrial, right? That 12th juror, that holdout juror, does not prevent the state from prosecuting the defendant in question, even though there has been a hung jury. What that 12th juror has done has been to require the state to do it again. And if they can't prove to another jury that there is guilt beyond reasonable doubt, because that jury comes back with an acquittal, then you know that one lone juror who held out actually functioned as the 12th juror and did something important in that case. Why would it be any different for a 13th juror? Essentially, what manifest weight is really all about is just giving that last juror an opportunity to vote after everything is said and done. And that last juror might say, I don't know, I don't feel it. Hung jury. It takes a unanimous 12 juror conviction and turns it into a 12-1 conviction, where the appellate court sitting in the place of the jurors in addition to the jurors who were in the trial court. There is no double jeopardy, as I said, because it's Tibbs versus Florida. So there is no real concern here that you're going to let innocent or guilty people go free, right? You're not discharging them the way that you would do in a sufficiency review under Jackson. You are saying that they deserve another trial because we lack the confidence in the integrity of the trial that led to this conviction. But it's available only in 3 states.
As to break the implicit bias, and you grant the order to have a new trial, what's going to be different? I mean, it's just putting the gerbil back on the wheel.
Well, it's a great question, Judge Groves, and you can't know what the next jury is going to be. And I'm not here to suggest to you that if you give it another shot, that you will eliminate a wrongful conviction by virtue of that second jury, but you'll at least give it a chance. And there are other ways that judges can help jurors overcome their own implicit biases. Micah Thompson, who's out of the University of Missouri at Kansas City, has written all about the value of implicit bias jury instructions. In other words, remember, I told you, system 1 thinking can be overcome by system 2 thinking, but it doesn't happen without work. And so if you give the jurors the instruction that they are to be careful about how they make determinations based on implicit bias, that can help resolve the issue. At the end of the day, if there is another trial, that second trial, if it results in a conviction, the defendant has the same rights of appeal as the defendant otherwise would. And whatever error, including manifest weight, that defendant wants to argue, it can be argued again. There used to be, Appellate Rule 12 used to prohibit a second reversal on manifest weight. It no longer does. That has come out for about 10 years now. So I guarantee you that I am not suggesting this is a perfect solution, but it's at least in the right direction. Texas and Florida have both struggled with this idea of manifest weight, and eventually both of them got rid of it. So instead of taking a step in the right direction, they took a step in the wrong one. Now, let's take a look at our appellate panel here. Let's say, I skipped a slide here. Let's say we've got our 3 judges who are sitting on the appellate bench, and they are asked to overturn a criminal conviction based on manifest weight. So they might all vote to affirm. And if that's the case, the conviction stands and there is no remedy for the defendant. Or you might get 2 reversals, or 3 reversals, I'm sorry, unanimous reversal. And this would, of course, be overturned for manifest weight. What about 2 reversals and 1 affirmance?
It's called mess.
It's called mess, right?
Or maybe that was 2 affirmative.
This case would be affirmed in Ohio if it's 2-1 in favor of reversal, because under the, in a jury trial, right? Because under the Ohio Constitution, only a unanimous panel of 3 judges can override a jury's decision of guilt. Think about that. Does that make sense? In a time when the systematic recognition, the recognition of systemic issues in the justice system is at its height, which it's terrible that it is there, but it's wonderful that we're looking at it now more closely, right? In the 1960s, the civil rights movement left everybody, well, not everybody, it left a lot of people feeling like everything's better now. We don't have to worry about racial issues in the justice system. We fixed all that with you know, awakenings and legislation. But we know that isn't true. We know that isn't true. And so if there is a need for correction for those 200,000 people who are wrongfully convicted, why would we demand unanimity on the appellate panel? To the contrary, I think that you should be able to get a conviction overturned on manifest weight grounds, even if you have only 1 appellate judge who thinks there's a problem. Let's look at why. So in this scenario, where 2 of the judges would affirm on a manifest weight challenge, and the 3rd one would reverse, maybe this judge is thinking the jury just wouldn't accept that it was a peach. And if one of those judges feels that the jury wouldn't accept it was a peach, why should that reasonable doubt on the part of a jurist, a trained lawyer with practice experience, often criminal practice experience, why should not that judge have the same power to be the 13th juror as the panel in its entirety has? What is the policy justification for not giving that power to each judge on the panel, other than tradition? Of course, there are some easy answers to that question. There are easy answers to what the policy justification is. It's obviously more work. It's obviously more uncertainty. It obviously sends more cases back for retrial. But is that really such a bad thing if one of our appellate judges thinks the jury got it wrong, and we know that the wrongful conviction rate is as high as it is? So this case would be reversed per my proposal. And let's look at why. Why single judge reversal? Relative competency. Relative competency. What do we mean by that? A background that brings a particular judge to the bench may not be the same as the background that brings the other two judges to the bench. Think about that concept of diversity in the judiciary and how our Supreme Court looks very different today from how it looked a year ago, and very different a year ago from how it looked 4 years ago, right? That kind of diversity is hugely important to the judiciary, and the only way to empower it and give it teeth is to give every judge the power to do justice. Training, every judge is a trained lawyer. This concept of jury unanimity. There is a recent US Supreme Court case that says that the states, there were 2 states, Oregon was one of them, and I can't remember the other. The states that said that a criminal jury could convict even without unanimity. 10 out of 12 jurors, I think it was in Oregon, could convict. And the Supreme Court, even this Supreme Court, said, no, it's got to be unanimous. That kind of a verdict that is not unanimous, to allow that to stand is a relic of the time in our country when Norris versus Alabama was decided, and excluding people of color from the jury rolls was just one of many tricks to avoid having a defendant of color acquitted by having somebody look at the case from a perspective that was not uniform, right? The uniformity of all white juries, for example, which was prevalent in the South, it's unconstitutional. And so why would we not require unanimity on the appellate bench as well to affirm a conviction that is being challenged as against the manifest weight? That unanimity is central to our conviction process. Why just at the trial level? And then, of course, you know, the 230,000 people wrongfully convicted, if that's not a powerful enough argument for you to buy into this, then nothing that I can say will get you there. Yep.
What would be the purpose of a jury in this system? I mean, they're the people in the courtroom, they're seeing live testimony in the evidence that the appellate judges aren't able to see in the same fashion. They don't get to hear inflections or tone or fidgeting or any of the mannerisms that the jury sees and evaluates. And we're going to give 3 vetoes, and only one of which needs to be exercised to wipe out the conviction that required a unanimous jury.
So the question for those who didn't hear it is, why would we give that kind of veto power to an appellate judge when our system is designed around having juries decide cases? They're the better position to evaluate the evidence and so forth. On the institutional competency piece, I just revert you back to what I said before, which is that it's a mixed bag. But the question is, why have a jury? Well, my answer to that is because every path that stands in the way of conviction is a guarantee, for the constitutional guarantee, that there's going to be more due process. So if the jury acquits, we're done, right? But if the jury convicts and all 3 appellate judges are fine with that, we're also done. So you still got to go through that jury process. They are essentially the gatekeeper to a conviction, but the appellate court is the safety net that prevents the wrongful convictions from, or theoretically, from being upheld. So to me, they work hand in hand. And I don't see an inconsistency there. I agree with you that we are in some ways watering down the role of that first jury, but don't forget that if an appellate judge vetoes what that jury has done, it goes back, as Judge Groves noted, to a second jury. It's still ultimately the jury's decision, as long as the issue that we're dealing with here is a factual one and not a legal one.
But every time it goes back, more time has passed. Witnesses begin to no longer show up for these trials. You lose other evidence. It deteriorates over time.
So that's all. What we are going back and forth about here is really just a value judgment. If you value expediency over eliminating wrongful convictions, I'd agree with you 100%. I put my value eggs in the other basket. That's just my personal view. Yep.
Follow up on the jury question. The jury is a group of 12 individuals with their own life experiences, with their own implicit biases.
Mm-hmm.
So they act as a unit together. So they go back into the jury room, they confer with each other, they talk to each other, and therefore you have a diverse jury in there. They've all heard the evidence. They sit there together and they obviously deliberate and they come to a conclusion together. Right? So it's not one person's implicit bias taking over the jury. And they were the ones who were there. They heard the evidence. They're in the best position to point out the credibility and the contradictions. And if they miss any contradictions, I'm sure that the defense attorney brings it up in closing argument and points those contradictions out to them. And if the defense attorney doesn't, they already have a ineffective assistance claim there. And you want to take the jury and put the jury's decision as a group of people. You want to be able to have one judge sitting on the Court of Appeals making a decision on their own without conferring with the other 12 jurors and having their decision and their own implicit bias come to the decision that we need a new trial.
Yes.
Is that your position?
Yes, that's exactly my position. That's exactly my position. Thank you.
The judge's implicit bias trumps the 12 jurors who come together. His implicit bias is mitigated by deliberation.
I mean, you're assuming that the judge who comes to that conclusion is exercising implicit bias.
You're
Judge,
assuming the jury is
no, I'm not assuming anything. I'm giving the power to the judges to.
of this entire, your premise of your entire argument falls. You're not assuming implicit bias.
I don't think it does, but I would suggest that you advertise yourself as willing to speak next time and you can give the counter argument. You're doing a great job of it. Yep.
Panel, I would say not as the 13th juror, but as the 13th, 14th, and 15th jurors, any of them who can hold out. So if we get, 3 affirms there, do we actually get like another 19 jurors if we can somehow manage to pull an en banc panel, get rejected there, and then take it up to the U.S. Supreme Court? Do we continue to apply?
Where is the end? Is that what you're asking?
I mean, the end is certainly no further than the Supreme Court, but like I'm wondering, does your proposal, allow for continued like one judge rejection?
So first of all, my proposal is so theoretical and so unlikely ever to see the light of day in any actual jurisdiction that I'm not bothering with the intricacies of those details. But I will tell you, and I think it was, I can't remember who asked the question, well, what if the second appellate panel wants to do the same thing, or one judge on the second appellate panel? And my answer to that is I trust our judges enough to have the history of the case be part of what they consider. I would imagine that the judge who reversed the first case and then it comes back and a second jury has convicted might think a little bit more carefully about reversing it a second time if they want to give that deference to the jury. It's just a safety check, right? It's just a way, because we all know juries get it wrong. And when we know that juries get it wrong, none of these other arguments to me carries any weight at all, because you've got 230,000 people sitting in prison who shouldn't be there. And to me, that's a greater injustice than any of these critiques, which I welcome. I get your points. Anyway, the remedy is, to emphasize this, the remedy is a retrial. It's not discharge. So you're not sending criminals out onto the streets. You're giving accused defendants who have been convicted once an opportunity to get out from under what at least one judge perceived was a flawed trial. But maybe this will help, because you're rightly wondering, how does that single judge who might not agree with her colleagues make a decision to reverse with all that power, that veto power? And here's what I would say to you. You don't have to have any evidence of overt bias. There are very few instances when overt bias is present in the record. That's what makes this so nefarious. The couple of times that it happens, it gets called out on appeal. Justice Sotomayor wrote a concurring opinion in a case in which a federal prosecutor used ethnic stereotypes to convince a jury that the defendant was in fact a drug dealer. And by the way, I will say that I have been present in a courtroom, as I know at least one other person in this room has, when one of our 8th district judges asked a question that absolutely suggested implicit bias because there was nothing in the record to support the factual predicate for that question. It was all because it was a parental rights case and our client was African-American. I'm certain of that. So it happens at every level. You need to have folks on the judiciary who have the power to step in when it does happen. So you need one or more of the following. You need serious conflicts in the evidence that are patent in the trial record on dispositive facts. There has to be an actual conflict in the evidence, or a serious possibility of a verdict that was based on improper race-based propensity, which you might be able to glean from either the voir dire of the jurors, or something that happened in the course of the presentation of the evidence. A serious possibility of tainted credibility determinations. And this is where that transcript review, I don't care how good your defense counsel is, they're not writing down every word. They can't argue to the jury everything that comes out in the trial. Sometimes they don't even hear it, but a record will disclose it. And then a serious possibility of a coerced confession, depending on the circumstances of evidence of a confession and how it was presented. To me, that ought to also be a factor that goes into this. So, and then a conviction that is premised on cross-racial identification is also a good candidate for studying very closely to see how strong the other evidence against that same defendant was, considering what we already know about the inaccuracy overall of cross-racial identification. So that is my proposal. I am delighted that it has inspired so much controversy. I don't know that I ever hoped it would get this much attention, and the pushback is just great publicity for me if you keep going with it. So thank you very much for your time. Does anybody else have any questions? We have a couple more minutes. Yep.
As well, I think what the gentleman was talking about was, you started this by saying that system two thinking is a way to overcome the implicit biases. And I think what he was referring to, that there are many examples of system two thinking from the very beginning, from the police investigation to the prosecutor's evaluation of a case, to the jury deliberation, to the defense attorney's closing arguments. So there's a lot of opportunities for system two thinking in this process, and yet it's still inadequate. And what I'm going to ask you is, why do you believe that it's still inadequate, even though it's already kind of in, some of it's already in there?
Because the jury has no role in any of those other opportunities, right? It's the jury's system one thinking that we're worried about here.
This is part of system two thinking, right?
It can be, but if you accept the premise that every jury studiously overcomes whatever biases that they may have, and they never reach verdicts that are tainted by bias, if that's what you believe, then maybe you're satisfied with it. I don't believe that. Other questions? Yep.
So to kind of bring it in more to the practical of how this standard is currently working, I was looking at a case recently from the 8th district that talked about two of the judges voted manifest weight to overturn a conviction. The third said, this is not the rare case where that should happen. In your research, do you feel that maybe because we have other maybe safety or relief valves, post-conviction remedies, habeas, that maybe some judges are a little more likely to say, okay, on a direct appeal, I'm not going to be that one to say, I'm really going to stick with the jury, because this is the true wrongful conviction, the true wrongful conviction, that there's a post-conviction relief somewhere out there that I'm not going to answer.
Yeah, if that's what the judges on the appellate panels are thinking, I've got news for them. The last thing you want to hang your hat on is post-conviction relief, and the very last thing you want to hang your hat on is habeas. So those may have been designed to help prevent injustice, but they are woefully inadequate to the task. I'm sorry, I'm happy to entertain questions after, but I don't want to go past my time. Thank you all very much.
Good afternoon. If it's not November, I'm still Judge O'Sullivan. We brought this to you today. We'd like to talk to you today about something that's more important than anything else you've heard today. It's your health, something that concerns us all. I know that when I first became an attorney back in 1990, the ABA published these outstanding numbers. 10% of the general population is likely to be suicidal, become an alcoholic, or become severely depressed. But only 13% of surgeons. So surgeons, because it's so stressful, it's a little higher. Lawyers is 25%, trial lawyers is 35%. So the ABA, we went on for 30 years, and Mr. Moat and I were just talking about this. They published the numbers again a couple of years ago, and it's still 10, 25, 35. So your mental health is one of the more important keys that you have to being a successful attorney. You can't argue any of these things if you're in a hospital somewhere, if you have a heart attack, or you wrap your Mercedes around a tree at age 50, like I've known many people not in this room to do. So Scott Moat is here. He's the executive director of OLAP, the Ohio Lawyers Assistance Program. He tells us that he has been sober himself since January 7th of 1985, which I cannot say the same thing. That's the year I graduated from college. Scott was a general practice lawyer for most of his practice, but is now the executive director of OLAP and also enjoys golfing and loves to go to museums and enjoy the art, which is one of these keys about this whole thing is you have to find ways that are healthy to relax. And Scott has done that. So I'd like to introduce to you Scott Moat.
Good afternoon. Pretty day to drive up here. The leaves are kind of dull though. They're just not really, really bright. I'm Scott Moat. I'm an alcoholic. Come on, one.
Hi, Scott.
Hi, Scott. There you go. Thank you. You got to see 28 Days. It's on Netflix again. It's really good with Sandra Bullock. I cried through most of the movie. It's a little bit close to home. I'm Scott Moat. I'm an alcoholic. And by the grace of God, one day at a time, I've been sober since January 7, 1985. And I grew up in a small town in Western Ohio down near Dayton called West Milton. And it was a community for people that commuted into Dayton, commuted to Troy, Vandalia, et cetera, to work. I was a good boy. It was kind of like a Leave It to Beaver, if you're old enough to remember that. Upbringing, four merit badges shy of an Eagle because I got a driver's license and a girlfriend, and that took care of those priorities. A good student, a leader in the school, a leader in the community at my age group, a pretty good jock for no bigger than I am, all of those things. And after a high school football game in 1965, I'm 15 years old, sophomore in high school in Nellie Lowry's woods on the edge of town, had a bonfire. Somebody brought 3-2 beer in. That's how old I am. We still had 3-2 beer. I'm 72, glad to be here. I had my first beer at age 15. And I didn't like the taste of it, but I love the way it made me feel when that ethyl alcohol hit my brain. And it was like, I have been waiting for this my whole life. This is the best thing that could ever happen to me. How do I get more? And what I found out in January of 1985 at Talbot Hall, Drug and Alcohol Treatment Program, now part of the Ohio State University Medical System in Columbus. What I found out during my 28 days inpatient treatment for chemical dependency, alcoholism, was that I had a genetic predisposition to chemical dependency, to alcoholism. Alcoholism runs in the male side of my family. And what I did in 1965 was trigger a genetic predisposition. And I spent the next almost 20 years, the professionals told me, trying to find that buzz again, trying to find that sweet spot again in the pleasure receptacles in my brain. Trust me. At no time in my 20-year drinking career, at no time in all of the fights with my wife, at no time looking myself in the mirror and hating the person who was looking back, at no time when I shirked my client responsibilities, at no time when I dipped into my trust account to pay a bar bill during those last years of my drinking. There wasn't a single time that I did it volitionally, that I became an addict volitionally. I've been sober now for 37 years plus, one day at a time. I've gone to, I don't know how many 12-step meetings, and I don't care. I'll just keep going. I don't know. I've helped over 3,500 lawyers, judges, and law students in the state of Ohio with addiction and mental health problems. I have yet to meet anybody who said, I became an addict intentionally. I have yet to meet anybody who said, I became mentally ill intentionally. Haven't found that person yet. If you're in the room, please identify. Yeah. So in my 30 years of practice in Columbus, primarily what I did was civil litigation. I was in a small firm. We represented family closely held corporations, kind of stuff, real estate developers. And when the litigation started, that's when I got involved in the business litigation side, did some domestic relations type stuff. You know, what you're doing as a trial lawyer is you're letting somebody tell a story, trying to create a story here, line and the story. So I found it helpful to let my clients speak in working with the Ohio Lawyers Assistance Program, because I can stand up here and do the medical, well, it's not a very good medical speech, but I can give you statistics and numbers and all of that kind of stuff, chemicals and whatever. But I think if we listen to our colleagues talk about how they get here, what's happening, what's going on, what I need, kind of thing. I think, you know, perhaps you get a better idea of what we do with the Ohio Lawyers Assistance Program. You know, I was listening to Professor Paulus talk about, you know, the publicity. I'd love to see us be able to put the Ohio Lawyers Assistance Program out of business, but I don't think that's going to happen anytime soon. The first one I'd like to talk about, this is an Ohio guy. This is a kid out of Minneapolis, St. Paul. This was sent to me by my colleague, Joan Biebelhausen, who runs the Minnesota Lawyers Concern for Lawyers program. This is out of the Minneapolis Star Tribune newspaper from a few years ago. Christopher A. Oster, second year University of Minnesota law student, age 22, of St. Louis Park, Minnesota, took his life on January the 14th. Beloved son and brother of the devastated parents, Paul and Daniel, survived by siblings Kim and Jonathan. We will miss forever your brilliant wit and charm. And Joan went to the University of Minnesota Law School, and she talked to classmates, she talked to faculty, she talked to administrators, and she found a lot of people there who observed Christopher Oster during his first year of law school, first semester, second year of law school, decline. They watched him spiral down. He came in vivacious and engaged, and they watched him stop going to classes and get dark and gloomy and gray, resulting in eventually him just making an irreversible decision to kill himself after finals his first semester of his second year. It's no one else's fault that Christopher Oster killed himself. What she couldn't find is anybody in that law school who took the time to say, hey, Christopher, are you okay? Is there anything I can do to help? And I don't fault people who don't come forward with those questions. It's a tough question. You don't know what the response is going to be, but you don't have to ask the question. I get 2 to 4, 6 suicidal lawyers a year. In Ohio, we get a couple, 3, 4 who will actually go through it. Some of them I've been working with, and they haven't been able to grasp the change and get out of despair and choose to go in a different direction with the professional help that we've recommended to them. Occasionally, I'll get the phone call, usually on a Monday morning, by a lawyer someplace in the state who's angry. I can hear it in their voice, and they say, why didn't you help Mary Smith? And well, who's Mary Smith, and why are you calling me on Monday morning? I can tell you're angry. What's going on? Well, Mary killed herself over the weekend. Well, how long had Mary been having difficulties? Oh, everybody in town knew she was in trouble for at least a year. Why didn't you call me a year ago? So if you haven't seen it yet, if you do at some time, I don't care. As I said, you don't have to be right. You don't have to diagnose. You don't have to fix. You don't have to do anything, but be willing to reach out to somebody else who knows what to do, how to do it, to try to intervene in somebody's life before they make an irreversible decision, because we get them in the profession. You know, the Ohio Supreme Court did away with the mandatory substance abuse education in January of 2014. So I'm here because it's not required. I'm just part of professional conduct now. If you recall, if you're old enough, we used to have to get a half hour every 2 years. The court did away with that. But interestingly enough, the court did not do away with the 1 hour of mandatory instruction to take the Ohio bar exam. So we still get to go to all the law schools, including this one. So I get to go to 4 or 5 of the 9 a year, whatever it is, depending upon what our schedule is like. And invariably, it seems I'll get a phone call or an email or something within the first 24 hours after a presentation. It's just like clockwork. So this is an email that I received. I spoke, this just happens to be at Ohio State. I spoke in the afternoon. I probably finished at 4:30 or something, and at 5:02 in the afternoon, I got this email from a female 35-year-old third-year law student. I attended the presentation you just gave. I have obsessive compulsive disorder, but I am not medicated, as I have never found anything that works for me. I also think about killing myself all the time, but I do not consider myself suicidal because I would not actually go through with it due to my responsibilities to the people around me. My boyfriend has asked me to seek help repeatedly, but I don't have the money, time. And I'm worried that if I'm officially diagnosed with a mental illness as an adult, I would have a hard time being permitted to take the bar exam. I was first diagnosed with OCD at age 11. So we're 14 years later, coming out at the end of law school and recognizing that my coping skills are starting to not be enough. And maybe I can reach out and get some help. And I responded to her immediately. We met with her the next day, did an assessment, referred her to appropriate counseling, helped her get the counseling she needed, the medication she needed, and she was permitted to take the bar exam. And her life has gone on the way it can be when somebody reaches out and provides some help. I happened to speak at one of the other law schools in the state one morning, and I got this about a half hour after I finished. This is an email again from a female third-year law student at that law school. I was at your lecture this morning. I need help. I have been suffering from depression for as long as I can remember, stemming from being molested as a child. My life has been a textbook case since then, ranging from re-victimizing myself through rape to reckless behavior to not being able to connect with anyone. I thought I had it under control, but lately I feel myself slipping. I am on antidepressants, but they don't seem to be enough anymore. I tried the counselors through school, but they were of no help. And I responded to her immediately and went to the law school, arranged with her, calling on the phone, arranged with her to go pick her up and bring her back to our office or our clinic. My clinical director at the time did an evaluation, did an assessment, and the recommendation of my clinical director was, let's take you to an emergency room and let's get you medically stabilized because you're not. She agreed to do that, and she voluntarily admitted herself to the hospital for 3 days, where they got her evaluated and got her on the right kinds of medication she needed in order to treat the clinical depression and the anxiety. And when it's time to take the bar exam for her, we made full disclosure to the highest Supreme Court Office of Attorney Admissions about what's going on, what she's doing about it, and how she's being treated, and all the excellent things that she's doing. And the Supreme Court said, hey, there's absolutely no reason why you should not be permitted to take the bar exam. And she also has gone on to having a successful legal career because we were there to help. And I'm here because you guys pay for the Ohio Lawyers Assistance Program and support it out of the Attorney Registration Fund. I spoke at the University of Akron, and they do an all-school thing twice a year, once in the spring, once in the fall, in a great big amphitheater that must seat 300 people. I don't know. It's huge. So I did that in September a couple of years ago and came home from playing golf one Saturday in October. And this is a series of emails exchanged between myself and a law student at the University of Akron at that time. Sir, I hope you're the gentleman who spoke to a group of us several weeks ago at the U of Akron. I have some questions I would like to ask. But I need to be sure of several things before doing so. Once I verify that this is the person, I want to inquire about several things. Thank you for your consideration, and I respond. I spoke at Akron on 9/17. Feel free to ask away. All contact, including your identity, is confidential, and he responds. I believe I need some sort of assistance. Life is beginning to spin out of control. I thought I could handle it, but now I'm beginning to realize that this is not necessarily the case. And I respond, let's think about you coming to Columbus and meet with one of my clinicians. It takes 2 hours to drive here, and assessment takes a couple hours, so we need a day. Happy to talk on the phone. Give me a call Monday morning, 9 to 11. I leave at 11:15 for the rest of the day. I'll be in on Tuesday after 1:30. If you can't wait until tomorrow to talk, call me at home. And I gave him my landline, my cell phone. I look forward to helping you get to a better place. He responds. I am in class from 9 to 12:15, so I will try to call on Tuesday. Further, I don't have a car anymore, so I have no way of getting to Columbus, and I respond to him Sunday night. I can send a clinician to Akron. We'll figure this out Tuesday. Are you thinking about killing yourself? His response, that is a difficult question to answer right now, no. But I drink 1.75 liters of vodka per day straight. And I never heard from him again. Typical alcoholic behavior, typical substance use disorder behavior. I'm in crisis mode. I reach out for help. I need to do something here. I did it myself more than once. I'm in trouble. I need help. And then I go, well, wait a minute, not that bad. Not that bad. I'll get by okay. I'll get by. I can do this. I can't tell you the number of times I asked God to let me get through this one and swear that I will never drink again. And the next day I drank. Never heard from him again. Heard about him. The law school called me early in December. Hey, have you ever heard of this guy? One of our first year law students, people says he drinks a lot. And he drinks a lot. And he's just kind of disappeared on us for the last 10 days. Nobody seems to know where he is. We thought maybe he reached out to you. I recognized right away who they were talking about, but because of confidentiality, there was no way I was going to acknowledge that I had ever heard of this young man. So I don't know whatever happened to him. But it's my understanding that he never finished this. Yeah. This is a smart kid. He's like you, he's like me. He's motivated. And his addiction is now taken away. Everything he'd worked for up to at least age 21, 22, 23, whatever it was, gone. Opportunity gone. I got this email in my box on a Tuesday morning. This is from a lawyer in Columbus who I looked him up on the Escort website. And he was in like his 9th, 10th practice of law. He worked for one of the government agencies, state agencies in Columbus. And he sent me this out of the blue on a Tuesday morning at 9:13. Mr. Mode, it is very difficult for me to write this email as I have always found myself to be strong-willed and capable of controlling my lifestyle. However, I have reached a point where I'm compelled to ask what I need to do to get some help from OLAP. I am not a daily drinker, but when I do drink every weekend and sometimes on a weekday, I find it difficult to stop without having at least 10 drinks. Having done this for some years now, I want to be substance-free. Any direction you can provide to reach that end will help. And I responded to him immediately. Hey, that time my office was in downtown Columbus, still with my law firm. I'm at 37 West Broad. You're at 30 East Broad, the road's tower. You're a 5-7 minute walk from me. Why don't you come over, meet with one of my clinical people? Let's do an assessment. We'll tell you what we see. Nobody will ever know you're here because of confidentiality. You take the information that we provide and you choose to do with it what you will. We're here to try to help. Crisis mode. Oh, I need help. I need help. Nah, not that bad. It's okay. Never heard from him again. Heard about him. 6-8 months later, I received a phone call one day from a lawyer who identifies herself as a colleague of this fellow, working in the same office. And of course, because of confidentiality, I don't acknowledge to her that I have any idea who she's talking about, but I knew immediately who she was talking about when she used his name. She said, I'm really worried about him. We've worked together for 7 years. He's a great guy. He's got 2 kids. He's a really good lawyer. He's a wonderful friend. He's always been kind of a drinker, and it's just gotten worse and worse. And he screws some stuff up here at the office, and he needs help, and I don't know what to do. And I explained what we do at the Higher Lawyers Assistance Program about facilitating interventions. I said, be happy to facilitate an intervention with you, other people in the office. We might be able to get his wife involved. I don't know. But whatever we need to do, I can help with the Ohio Lawyers Assistance Program. Why don't you talk to your section chief? And get back to me if you think that's appropriate. I don't know if you should talk this. Oh, yeah, she knows. So, end of conversation. 2 days later, the woman lawyer calls me back and says it's too late. Talk to the section chief, and she's really angry because he screwed this thing up, and she's afraid that it's going to cost her a promotion that she thought she was going to get. So she fired him this morning. End of story. At that point. 12 months out, I'm reading the Columbus Dispatch, looking at the obituaries, and there he is. And I determined that he shot himself after having lost his job with the state government agency. He left a wife and 2 children. I just wonder if the section chief got for promotion. What he thinks about all that. So if you haven't seen a colleague yet, you will. If it hasn't happened to you yet, I hope it never does. But if you get to a situation where you have an opportunity to help somebody, I hope you'll call the Ohio Lawyers Assistance Program for somebody and not just look the other way. So Ron O'Brien in Columbus was the county prosecutor at the time of this email, and John Coughlin at that time was the Supreme Court Disciplinary Counsel. This is an email that O'Brien sent to Coughlin on a Thursday afternoon. The above attorney with the Westerville residence address was arrested yesterday by the county sheriff for possession of a felony amount of oxycodone and appeared in Muni Court today where a $50,000 bond was set. An inmate was making phone calls to family to contact him and giving drugs in exchange for representation. The family cooperated. The lawyer agreed to receive drugs and conversations that were taped. The drugs were delivered yesterday to him. He was placed under arrest. He advised the deputies that he knew that they were going to eventually catch him. This is a 52, 53, 4-year-old criminal defense lawyer in Central Ohio who has been practicing law there his entire career. And if there's anybody in the city knows that outgoing phone calls made by an inmate at the Franklin County Jail are not confidential, he does. And his addiction forces him to throw all caution to the wind. Forget about the negative consequences. I knew you were going to eventually get me, and arrange to get those drugs. And he was like the other 10, 12 lawyers that we have worked with, men and women over the years, who got themselves addicted to oxycodone, OxyContin. Every single one of the lawyers who I have worked with started out with a legitimate medical reason for taking the medication. Surgery, automobile accident, whatever it was, there was a legit reason for taking this stuff, but when they took it, their brain flipped on them. For whatever reason, usually because instead of taking one every 4 hours, they started taking 2 every 4 hours or 2 every 3 hours because the exhilarating effect was such that the next thing you know, they're addicted, and now they're on the street buying it. One of the women lawyers I worked with had pending felony charges in three counties in the southern part of the state because she had stolen a prescription pad from one of her docs and was falsifying prescriptions for her oxy and going to different pharmacies in a three county area in the southern part of the state where she lived in order to get them filled. Knowing, because she did criminal defense work and drug defense work, that the state DEA, equivalent of the DEA, is watching these computers all the time and seeing who's filling these prescriptions. She ended up going to prison. I had 3 county prosecutors and the judges in each of those counties all agreeing to try to hold off and let's get her into treatment. Let's see if we can't help her get moving in a different direction. We can deal with the criminal stuff later. Let's try to save her life. Let's try to save her career. Let's try to save her family because she had 3 kids at home. And she couldn't make it. And she ended up going to prison. So if somebody recommends that you take Oxy or somebody in your family takes Oxy, my recommendation is you ask if there's an alternative med. And if there isn't, then don't let the patient hold the bottle. In August 31 of 2015, another one of my genetic cool things that happened to me, I had to have open heart surgery because I got really bad arterial sclerosis and all that kind of stuff, the cholesterol thing, and I got blockage and I got the widowmaker and I found it because I got a huge pain in my chest playing golf, walking. Let's play golf. It's a wonderful way to find out if you need open heart surgery. It's warm enough today to play. It's a little bit windy to have to work on my knockdown 7-iron a little bit today. But I ended up, because of genetic predisposition, all the men in my family die of heart attacks. So I'm going to go eventually that way. You know, it's nice at least knowing that part of it. I guess. But when I was discharged, I told my physician, Dr. Fanning, I said, I am not interested in, I don't like to take anything that's a mind-altering substance. My brain will just go. I don't trust myself after 37 years. I just don't. It's the way my head works. And he said, I need you to take this because your body is in such pain. That's the only way you're going to heal. So I never did know where the Percocet was in the house. My wife Gretchen had the bottle, but I did know every 4 hours when that alarm on her cell phone went off that I was going to get another shot of Percocet. Yesterday, I don't know if you saw it up here. Yesterday, there was an article coming out of the court news from the Ohio Supreme Court about a lawyer named Adam Stone in Bucyrus, Ohio, and I'm not busting anybody's anonymity because it's right there in the Crawford County newspaper out of Bucyrus. This is what Adam Stone released yesterday, a press release to Crawford County Now. It is my understanding that the Ohio Supreme Court Office of Disciplinary Counsel released its complaint against me to the court and local media sources. As of this writing, I had not had an opportunity to respond to the allegations. However, well before the filing of this complaint, I already applied with the Office of Attorney Services as well as the Supreme Court Office of Disciplinary Counsel to resign and forever retire my law license. He was admitted in 2009. Having handled and defended the cases that I have over the last 13 years in state and federal courts, all the things that I saw and the recent passing of my grandfather and father created a situation in which my mental health needs addressed in an ongoing fashion. And I am undertaking that process to be better. In fact, my application to resign was supported by correspondence from my mental health provider who reinforced this decision to leave the practice of law. My first obligation is to my children, wife, family, etc. For a long time, I had forgotten that and prioritized my life in such a manner that bit by bit, I became lost in case after case of rape, murder, child exploitation, and many others. I do not want this for my family or for myself or my family anymore. I understand that some think this is somehow newsworthy, but my resignation has nothing to do with the disciplinary complaint. In fact, I haven't even read it in its entirety at this point. The reality is that I am resigning regardless, and I hope that all reading this will respect my privacy and the privacy of my family. And he even submitted a written report from his therapist, a statement from his therapist to the press. Because his career exposes him to deeply disturbing content, images, and intense psychological demands, this letter is written in support of his decision to discontinue the practice of law until he is better equipped to manage the emotional aspects that are inherent to the profession. It is my opinion that Adam's work-related stress has had a tremendously detrimental impact on his mental health. Although he may be quite skillful in his trade, it is advisable for him to step back at this time to prevent further decompensation and permit him to focus more on self-care and recovery. I have never seen that before. anywhere, let alone Ohio. I have never seen that before. A few years ago, I spoke for the Midwest, State Bar Association, Midwest Labor and Employment Law Conference. Anybody do labor law? These people had a 7:30 in the morning seminar. Jeez, I don't even take a 7:30 tea time unless I have to. I will get in a duck line at 7:30 in the morning and a deer stand, those kinds of things. Back when I did that. Anyway, 7:30 in the morning, I am at the Hilton Easton, and there are probably 500, 700 lawyers from all over the Midwest in their labor lawyers. And I spoke at the seminar, and then I left and went directly to the golf course to play. They stayed on Friday and did their seminar, but be that as it may. I got this email the next day from a fellow who I had never heard of before, and this is what he said. Hi, Scott. I had the pleasure of hearing you speak at yesterday's Midwest Labor and Employment Law Conference. I am an ex-year associate with a lawyer in a large firm in X city. 3 years ago, at the age of 32, I was diagnosed with chronic and serious depression and on the verge of suicide. Neither my wife, family, nor friends knew that I was feeling this way. It was hard to get out of bed in the morning, and I was engaging in other self-destructive behavior that would have, at the least, destroyed my marriage. Over the years, I had contemplated suicide at various times in my life. At this time, I had a plan. I went as far as to sit down at my desk and begin writing a goodbye letter to my family and friends. After my breakdown, I remember admitting to my counselor that I had contemplated breaking the window and jumping from my office on the 32nd floor. I knew I had a problem, but I thought I could fix it on my own. Eventually, I went into counseling, and with the help of my family and friends, began to realize what I needed to do to change my life. Mental health issues run in my father's family, and maybe that combined with this high stress career caused me to become a danger to myself. Today, I'm still at the firm where I was when I had my major breakdown. My career is as strong as ever. My marriage has been repaired. We're expecting another child. I hold various leadership positions both in and out of the legal community. Most of my colleagues don't know my past mental health issues. If I could offer advice to any lawyer or law student, young or old, I would tell them not to be ashamed of feeling the way I did and not to be afraid to ask for help. Mental health issues do not fix themselves. Everybody in this room has probably heard of a guy named William Rehnquist, right? I mean, how can we not? Okay, so William Rehnquist in 1986 is a sitting associate justice on the United States Supreme Court. Ronald Reagan nominates him to become the Chief Justice, and in connection with that nomination, as we know, that brain trust known as the Senate Judiciary Committee. That's the nomination. Do we confirm or deny? And in connection with the background information, the vetting, the Senate Judiciary Committee has William Rehnquist's medical records. For years and years and years, they are not open to the public. Eventually, under the passage of time and because of Freedom of Information Act and all that kind of stuff, eventually the medical records become available to the public. And here is some of what the Senate Judiciary Committee learned about Justice Rehnquist. Also detailed in the declassified file was Rehnquist's 1981 hospital stay for treatment of back pain and his dependence on powerful prescription pain relief medication. The FBI investigated his dependence on Placidil, which Rehnquist had taken for at least 10 years, according to a summary from a 1970 medical examination. When Rehnquist checked into a hospital in 1981 for a week-long stay, doctors stopped administering the drug, causing what a hospital spokesman at the time said was a, quote, disturbance in mental clarity, close quote. The FBI file, citing one of his physicians, said Rehnquist experienced withdrawal symptoms that included trying to escape the facility and discerning changes in the patterns on the hospital curtains. The justice also thought he heard voices outside his room discussing various plots against him. Prior to his hospitalization, Rehnquist occasionally slurred his speech during his questions to lawyers at Supreme Court oral argument. Wow. Chief Justice of the United States Supreme Court is a drug addict. What other conclusion do you draw from that? Now, let me ask you this, hypothetical. Do any of you think that William Rehnquist intentionally became addicted to prescription pain relief medication? Like I said earlier, in my 37 years of recovery, in all of my years of working with the Ohio Lawyers Assistance Program, I have yet to meet anybody who said, gee, I decided when I was 32 years old, I'd become depressed, clinically depressed, and lose everything, just become an alcoholic and go live in a shelter. Haven't found that person yet. I haven't found that person yet. You know, I talk about law students and I talk about lawyers, and I end up talking about a guy that becomes the Chief Justice of the United States Supreme Court. You know, and where does it start with us? Yeah, and the judge alluded to it with the ABA stats. If I brought my clinical staff here or any law school, first day of law school, right before they're getting ready to start, and they're all bright-eyed and scared S-less, you know what that means, about what's going to happen. And we did an assessment on the incoming class, first-year students. The numbers basically would show that 10% of the incoming class is diagnosable under the DSM-5 with a mental illness. Primarily what we're going to see is depression, anxiety, hostility, paranoia, obsessive compulsive disorder, one or a combination of those five diagnosable under the DSM-5 as a mental illness, 10%. That's the same number as non-law students. That's the general US population, generally 10%. So when we start law school, we're no screwier than everybody else. And I'm a little bit of facetious. I'm not making fun of that because I've been diagnosed with my own mental health issues. I grew up with a mother who was bipolar. Back when we called it manic depression, and it wasn't fun. It was kind of scary, but be that as it may. 10% at the end of the first year of law school. If I bring my clinical people back and we do an assessment on the kids that are still here, the number diagnosable with a mental health problem is tripled to 32%. Law school changes people. You think so? Did it change you? Mm-hmm. Yeah. Not bad or wrong, not good or bad. It's just, it's a fact. All right. 32%. It has tripled. If I come back at the end of third year day, fourth year night, do an assessment on the law students who are getting ready to take the bar exam and join us in the practice of law. The number diagnosable with a mental health problem has jumped to 40%. And the number doesn't go back to pre-law school days at 10%. It doesn't go back to the surgeons, 13%. It goes back to about a third. Statistically, 1/3 of the practicing bar, and I don't care where you are, where we are. If we are in courtrooms, if we're in government agencies, we're in nonprofits, we're in for-profits, we're in big firms, small firms, so I don't care where we are, 40% of us are diagnosable, a third of us, I'm sorry, are practicing law currently under a mental health disorder. It's not only having a negative effect upon our ability to practice law, the kind of job that we're doing for our clients, but what's going on at home? What's going on with family and neighbors and kids and significant others and partners and all of that? It takes a toll. You know, 25% of law students, when they start, are diagnosable with a substance use disorder. What we have actually found is that law students drink more when they get to law school than they did when they were an undergrad. It's an acculturation thing. The problem is, and when I talk to the kids, and some schools will let me on orientation, University of Cincinnati, when they called me and said, can you come down and speak to my professional responsibility class? And I said, sure, be happy to. Can I also get on the orientation? Give me 15 minutes so I can talk to the kids. She says, no way. She said, we're already so scared. We don't want you to scare them more. Talk about hide the facts. Let's start law school by playing hide the facts. How about that? No wonder you're an academic. Excuse me for the academic. 25% of law students, 6% of law students have suicidal thoughts. Some studies have shown that as many as 15% of lawyers have suicidal thoughts. On the good side, the Texas Bar Association did a survey of their membership a few years ago, and 88% of the lawyers said if they had to do it over again, they would become lawyers again. So it's not all dim and dismal. It's not all, it's not all negative. But where I have found where law school changes people, and this is work that was done by Susan Dayclough, who was a psychologist and a lawyer, has an LLM. She used to teach at Capitol. She's elsewhere, went to Arizona. What she's found is that when we come to law school, and I don't know if it applied to you, but it did to me, because I came out of a liberal arts background. I had a bachelor's and master's in English, and I was staying in school as long as I could until Vietnam was over, because I had that 2S deferment. Then I got a high lottery number, and I went 1A so I could get through that, and I did. Then I had a career choice because I didn't know if they was going to take me over and shoot me, so I was kind of holding back on stuff for a while. They're peddling, trying to stay alive, drinking, and smoking the dope, so it wasn't all bad. I mean, we had good dope back then, not the stuff they have now, but it was okay. Tie stick, if you ever got into any of that, that was pretty good stuff. But anyway, I went to law school because I wanted to help people. It's an intrinsic value. I wanted to be part of the solutions. If you're not part of the solution, you're part of the problem. And don't trust anybody over 30. And now I'm 72, and here we are, with that. But that's where I grew up, and I wanted to help people. And I lost that for a while. I did it. But I started looking around, and I started looking at BMWs and country club memberships. One time I belonged to 2 houses, the accoutrements, the power, the influence kind of thing. I got acculturated into the deal. And getting sober for me gave me an opportunity to reconnect to who I was before I became an addict. And the addict wasn't all responsible for it. It was just I allowed myself to get sucked in to the promise of money, power, influence, prestige, and all that by being a lawyer. And statistically, that's what happens to us. And what I see in my office every single day are lawyers who come in who started out wanting to help people, found out that in order to do that in some fashion, if they could stick with it at all, required them to get into a profession that is built on adversarial positions. Everything that we do is surrounded by negativity. I practiced law for 30 years. I was never super successful, always had more money than I needed, kind of thing. Wonderful life. Gretchen, my wife's lawyer, I met her in law school. Our daughter's 37, she's in her 10th year, 11th year of practice in Columbus and doing great. We're the first lawyers in the family. I loved being a lawyer. What I got tired of were the clients and other lawyers with the constant negativity. And I say this kind of facetiously. In all of my years of practice and all of the cases that I handled, some more successful than others, maybe. I was always that guy that said, if I didn't get 150% result, I was a failure. Go figure. But the only time I didn't have clients complaining about something were like 2 uncontested adoptions or something. Everybody else, I don't care if I saved a client $1 million. I don't care if I made a client $1 million. I don't care what I did. Somebody complained. You charged too much. It took too long. I didn't want to do it this way. The guy I bowl with, his lawyer did this. I go, God, go hire the guy you bowl with. the negativity, and then we lawyers do it to each other. Like, you know, you get these lawyers that are mean and nasty, like I'm gonna suddenly fold and sell my client out because you're a jerk. You think this is gonna encourage me to settle because you holler and scream and pound your, and we do it to each other. You know, and I recognize the real world. No question, you know, and I say this all the time, you know, this whole wellness thing with lawyers, I think it's wonderful. I don't do goat yoga, never will. Don't understand that, but if that's your thing, go ahead and do goat yoga. You know, I'm more likely gonna go hit golf balls or go to the driving range, you know, go hunting, do something other than goat yoga. What I found is that we lawyers have a tendency to be so self-critical that we allow the negativity to change who we are and how we view ourselves, you know, subconsciously. We may not be conscious of it, but if you've got somebody complaining to you about what you're doing, how you're doing it, the result, what it costs, whatever it is, constant negativity, and it goes on for day after day after day, year after year, month after month, whatever it is. Eventually, you're in my office saying, I'm burnout. And I'm not saying that I can control what anybody else does. I learned a long time ago, 37 years actually, when I was in treatment at Talbot Hall, I had to learn that I can't control other people, places, and things. I can only control the way I let them affect me. I can't control other people, places, and things. I can only control how I let those people, places, and things affect me. My first visceral response to something might be anger or fear. I understand that. But I have the ability to step back and go, wait a minute. Wait a minute. And I don't have to get sucked into the negativity, destroy my own self-image, and we do that all the time. And it starts in these seats, perhaps, with lawyers. How many of you did not make law review? You ever have a client ask you if you made law review? I was working. I would have liked to have been smart enough maybe to write, but I was working full time. I had a full-time job with 2 shops in the tax department. Well, I was going to law school my last 2 years, so law review wasn't something that I would into. Did anybody ever ask you what your class rank was? Your clients? Ask GPA? Me either. Think back to when the list of people who made law review came. Think back to when you got your first grade, that you had never seen a grade like that before in your life. And it happened here. Right? I got mine. Got a buddy checking the grades as they come out first semester, and these contracts come out. And he says, you got a D. And I said, did you say D? As in dog. I was in Dayton, and I was in school at Stetson in St. Pete, Florida, and he was checking the grades as they came out when I was home after exams. He says, yeah, you got a D. I said, what did you get? And he said, a B plus. I said, geez. I went back to law school intending to withdraw. I had gotten like 2 B's, a C, and a D or something like that. And I had never gotten grades like that in my life. And I had really tried and studied with this group of guys. And what my contracts prof said to me was, he says, you know, before you came in here today, I took a look at your file. Your LSAT was good, your GPA is great, everything in your application is wonderful. You know, we would not have let you in here if we didn't know that you could be successful. Don't panic. You're used to being the smartest guy in the room. Everybody here is the smartest guy in the room. The competition level just changed. Do law schools tell their students that? No. That's why they won't let me on orientation. Don't panic. We wouldn't have let you in if we didn't know that you could be successful. Law firm setting, I get lawyers in my office all the time. They're solos. They're small firms, they're office sharing arrangements. I got a call earlier this week from a 59-year-old partner at one of the major law firms in Columbus, who's getting ready to walk out the door because he's just had it with the internal conflict among him and his colleagues, the people he used to think are his friends, who have not become too much friendly anymore because they lost one of their major clients and everybody's fighting over what pool of money's left. Wow. Wow. Grateful not to ever have have been in that position. You know, the other thing that I like to talk, I don't like to talk about because I'm getting close to becoming Exhibit A is the age-related cognitive impairment piece. I'll look at somebody I've known for 30 years and I go, Jesus, I can't even remember the name. Now, my excuse is I have so much information in here that it gets kind of jumbled up. You know, it's not age related. It's part of, I laugh with Gretchen, my wife. I say, I can't remember what the hell I ate for lunch yesterday, but I remember something that happened when I was 6 years old. Getting there. The profession, we baby boomers are aging for sure, and we are not prone to giving up lightly. We grew up in an era when you worked for what you got and you achieved what you were going to get because you put in the hard work for it. And let's not just walk away from this. After all, I don't have anything else to do for many of us. I do, but a lot of lawyers don't. And what I'm seeing now are calls from colleagues, from partners, and a lot of judges that have elderly lawyers appearing in front of them who are, let's be kind and say, mixed up. They just cognitively can't do it anymore. And we trying to help our colleague are kind of helping them along, but things are getting worse and worse. And I'm constantly concerned that what we're doing is enabling one of our colleagues to go out at the end of a wonderful career as respondent in a disciplinary matter and a defendant in a malpractice case. If we don't step in and call somebody. Once again, you don't have to be able to diagnose, you don't have to fix, you don't have to do anything other than when you observe the aberrant behavior, you observe the failing behavior, call the Ohio Lawyers Assistance Program, and let's get something moving in a different direction. The only cure I have for people say, what's the solution? Well, we could ask everybody in the world to be nice to each other. How do you think that's going to happen? You know, as I tell Jamie Dimon, the president of JP Morgan Bank of America, he's scared to death every single day, like everybody else is, that everything's going to blow up. There isn't anybody running around out here doing anything that's still breathing that doesn't have some fear thing going on. It's part of the human condition. Go back and read the classic. Go back and get into the literature again. It's not just, we're not learning anything new, in my opinion. And I'm the only opinion that matters in my life. The anger piece, we're not going to change society. So what we need to do individually and collectively, if possible, but certainly individually, is learn how to take care of yourself. And I think the first place and the easiest place to do that, just go online. If you don't already have a spiritual place to live, find one. That's a good place for me. But the other thing is to learn how to be resilient. And most of us have got pieces of it. But to start thinking intentionally about it a little bit more, because we're getting buttressed every day. We're just getting pounded every day. It's only getting worse. Nobody talks, everybody screams. It's all exclamation points now in capital letters, kind of thing. You know, we don't even have to talk to each other face to face anymore. I just shoot you an email. Give you a finger that way. You know, and it's wearing. It's not fun. You know, my daughter's 37 years old. She says, Dad, man, She said, I thought it would be more fun than this, and she does litigation. She said, you know, the mean and nasty stuff. She says, I'm not doing this forever. And I said, I don't blame you. She said, I'm getting a sailboat and going to the Caribbean. And I said, I hope I live long enough to come see you. Go for it, do it. Don't do it forever. So everything I do at the Hire Lawyers Assistance Program is absolutely confidential. Absolutely confidential. I remember we had a case up here years ago, and I got a telephone call from a woman who identified herself as a reporter for the Cleveland Plain Dealer, and this is 20 years ago. And it's kind of some notoriety to the case. Anyway, Olaf's name gets mentioned in something at the court or wherever it was. And she calls me on the phone. She demands information from me, you know, and I said, well, it's everything I do is confidential. I neither admit nor deny that I know the lawyer who you're talking about. And she says, well, you're a public agency. You have to give me the, I said, I'm not a public agency. She said, well, I'm just going to call, get hold of our lawyers and sue you. And I said, you still represented by Baker and Hofstadter? And she said, yeah. And I said, well, tell Jim Jones I said hi. You know? Take your best shot. Everything I do is confidential. I have never once been asked by the Office of Disciplinary Counsel to violate that. Never once been asked by bar counsel here in Cleveland. You know, never had a justice on the Ohio Supreme Court ask me to violate the confidentiality. You don't have to worry if you're calling for yourself or for somebody else that we are going to turn around and call your colleagues or call your spouses or call the court or call discipline or the bar association. It is absolutely confidential. If you're concerned for yourself today or somewhere down the road or for somebody else, anything to do with the kind of stuff that we talk about, and you can look at the stuff in the PowerPoint that I don't use, but I just put it up there because it makes me look technologically savvy. All appearances, isn't it? Happy, joyous, and free. If you're concerned, call us. You don't have to do this all by yourself. Thanks for the opportunity to be here.
All right, that does conclude our program. Wow, what a busy, fast-paced day. I hope you enjoyed it as much as I did. Remember, if you're in person, I see a lot of you have your attorney registration information so you can get your CLE credits. If you're remote, do I have to give the bar number? No, we're good with that. The written materials are from Case Law School where you registered for this event. You can be linked in to get the written materials. And as you see from our speakers, they spoke fast. They spoke a lot of opinion. They spoke a lot of law, but a lot of stuff is in the written materials. So do go there. Thank you again on behalf of the 8th District Court of Appeals and Case Law School. Thank you.
The activity code for this program is 499-242, 499-242. The evaluation for this is in the link. This message is for our virtual audience. The activity code is 499-242. Once again, for our virtual audience, the activity code for this program is 499-242, 499-242. The evaluation link is in your chat.
Talks about you all the time. I actually just received a movie. I was very was one of Molly's students in grade school and
The activity code is 499-242, 499-242. The CLE evaluation link is in the chat. 499-242. The evaluation link is in the chat. One last time, the activity code is 499-242, 499-242. This is for our virtual audience. The activity code is 499-242. The link to complete the evaluation is in the chat. Please click on the chat for the link and enter the activity code 499-242.